Hi, good afternoon everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly community conference call. We'll be dealing with the questions that have been posted, first the frequently asked questions and then the non-frequently asked questions. I won't have time to answer new questions. We'll be only able to do the posted questions and their follow-ups. Let me just make sure everybody can hear me okay.
The conference is now in conversation mode.
Can you all hear me okay, guys?
Yeah, we hear you.
Thank you.
Yes, Roger.
Okay, excellent.
The conference is now in presentation mode.
So let me go over to the frequently asked questions first. There are some questions. I didn't get the time to parse out the details of the questions. I can have that done later, but let me just answer those questions. Hemal 4321 has a question that I think is a frequently asked questions. A part of a frequently asked questions. It says, I'm currently working with employer A on H-1B. I-140 has been approved for over 180 days. Wife is on F-1 EAD. Planning to move from F-1 to H-4 EAD after I join employer B. And I'm joining based upon my approved I-140 from employer A. Of course, I-140 has been approved more than 180 days. Good. Now, these are the four questions that I think are frequently asked. Once I join employer B, will I be able to apply for my wife's H-4 EAD based on approved I-140 from employer A? The answer is yes. You can apply both change to H-4 and H-4 EAD concurrently. So even though you are working for employer B, your wife can derive the same benefit as you would from the earlier I-140 approval. You can apply for her H-4 EAD through the second employer. Through the H-1 through the second employer. So that's not a problem. So answer to question number one is yes, you can. 2. Will changing my employer impact my wife's eligibility to get H-4 EAD? No. Even though the I-140 was from the previous employer? No. It does not affect eligibility. Can I change multiple employers based on I-140? What if the employer B has already started my green card process? Well, you can change employers as many times as you like. And once your I-140 has been approved 180 days, there is no limit to how many employers you can change and how long you can keep getting extensions of your H-1B, as long as the dates are not current. If the dates become current, then you can only get 1-year extensions, as far as I recall. So just because an employer has started your PERM application does not in any way stop you from leaving them. Of course, when you join a new employer, you would have to start your green card all over again. But the previous PERM is not stopping you. And the fourth question, which is very important. The question is, so I've got an approval from employer A of their I-140. 180 days have passed. Now I've got another approval through employer B of another I-140. Does the previous I-140 go away, get overruled? The answer is no. Both remain valid in their own right, and you can derive the maximum benefit, whichever is better benefit for you out of the two. *5 if you have a follow-up question on any of these. *5 if you have a follow-up question. Press *5 on your phone. Okay, let's go on to the next frequently asked question. This is from G. Gun, who says, I have an H-1B visa stamped from employer A, and the employer B has filed my transfer. Now, my H-1B filed by employer B is on RFE, and my employer A wants to file the green card based on my previously approved I-140 from employer C. So there are 3 employers in play. You have an H-1B visa stamp from employer B, from employer A. Employer B has filed for a transfer. H-1B filed by employer B is on RFE, and employer A, which is the previous employer, wants to file a green card based upon a previously approved I-140 from employer C. A lot of employers here, but the point is you've got an H-1B through one, you got a previously approved I-140 through another, and a third employer wants to start your green card based upon the priority date of the I-140 from a previously approved case. So can I reject the offer from employer B and still continue to work with employer A? So generically stated, the question is this: if I'm working for one employer and another employer's H-1B gets approved, am I required to change? And the answer is no. A prior approved H-1B is not overruled by a subsequent H-1B through another employer. If you have signed any contracts and all, that's a different issue. But as far as immigration law is concerned, having 1, 2, 3, 4, or even 20 subsequent H-1B approvals has no effect on a previously approved H-1B. Number 2, can I reject the offer from employer B and still continue to work with A? The answer is yes. In case my visa from employer B is rejected, do I need to leave the country? Not at all. As long as your employer A has not been revoked and employer B A is still, you're maintaining status through them, you are fine. By the way, I want to add something else. As I recall, under the new regulations, the government has actually made it clear that, let's say you were working from employer A. Employer B filed transfer. As the law permits, you move from A to B using your receipt. If B gets denied and A has not yet been revoked, you can actually go back and start working for A again. So without any break in status. So if you went from A to B, you could go right back from B to A again without any additional paperwork, as long as A has not revoked their H-1B. Okay. Fourth question, can I ask employer A to file my green card even if my H-1B from employer B is rejected? Look, any employer or any number of employers can file for your green card. There's no limit. The only issue is, are you doing it in good faith? Is it an honest intention to join them upon approval of the green card? These are issues that you should discuss with your lawyers who are processing your green card. But there is no limit to how many green cards you can file, and there is no requirement that you must be working with any one of those employers. Can I immediately file the green card with the employer B after joining? Absolutely. As I said, you can even start the green card before you join employer B. There's no requirement that you be working for that employer. But these are decisions that should be made in conjunction, in consultation with your lawyers. Star 5 if you have a follow-up question on any of this. Press star 5 on your phone, please. Folks, people who have just joined, I want to alert you guys that we won't have time for new questions. I have time only to deal with the questions that have been posted and follow-ups on those questions. No new questions today, sorry. Next frequently asked question is, people are still logging in. Again, just to update you, no new questions. Will be dealing only with the posted questions and their follow-ups. Nunc Tunk says, now this is a very common problem with investor visas. Okay, so you have heard on the radio that you can invest 500,000 and you will get your money returned back after 5 years. I have a problem with that. It almost appears to me to be illegal. One of the key requirements of EB-5 is that your money must be placed at risk. Any sort of arrangement that says your money will be returned is not an investment. That's either a loan or a deposit. Investment means there must be risk. So if there is an organization that is advising you they'll return your money after 5 years, that sounds to me almost illegal. I haven't looked at the exact wording of what they have said on the radio in Qatar, in Doha, Qatar, but it sounds really bad to me. There might be some companies, there are plenty of approved regional centers. I am very reluctant to steer people to any particular investment center, regional investment center. We tell people, look, we are not committed to any center. We are not investment experts. You have to decide what is a good investment. but your money must be at risk. Okay. And another thing is, any lawyer who is working on an ongoing basis with any particular investment center, I think they have a conflict of interest. Because I, as a lawyer, should be representing you, not worrying about which investment center you go with. That's something you have to decide. So, in theory, this idea that your entire money will be returned, it is actually against the regulations. You asked me about conditional green card. A conditional green card is as good as a real green card for almost all activities. And your son can finish their graduation as well with the same status. Project does not have to be completed. It works differently in different situations. This is a long discussion. I'll try to sum it up as quickly as I can. The way this works is, when you are doing an investment-based green card, you have, first of all, you have to look at all these moving parts. One set of moving parts is, do you want to invest $500,000 or $1 million? Second moving part is, do you want to run the business yourself or let somebody else run the business? So when you invest $500,000 in an approved investment scheme, remember, it is only approved for immigration compliance expectedly. They can still mess up, and they do. There is no guarantee that this scheme will be successful or your money is safe. So don't think that just because the investment scheme has been approved by the government, it is either safe or even honest. Nobody can tell you that. You have to assess that. There are some services out there who help you make those decisions. I don't recommend any. I have never used any. We have dealt with EB-5s through investment centers as well as individual businesses. So if you want to start your own business, what you have to do is invest either $500,000 in some of the areas that are considered to be rural or targeted employment areas where the unemployment is about 50% higher than the national average. Or these two areas are the one where you can invest $500,000. The way the process of the green card works is, once you make your investment, whether it is an investment center or your own particular business, you can then file the first set of forms, which take almost 2 years to complete. Add to it another 6-8 months. Then you get your green card, your conditional green card. So it takes between 2 and 3 years under current environment. It could go up. Once you get your conditional green card, you can come to the USA. You can start living here. Your son can start going to school. 90 days before the end of the 2 years, another set of forms is filed to remove the condition that shows that 10 American jobs have been created and that the investment is on track. That's when you get your permanent green card. That, in a nutshell, is the situation. *5 if you have a follow-up question on this. *5. Okay. Another frequently asked question is, this is also a very important question. People are concerned that if we have taken any kind of benefit from the government, would we be losing our naturalization? Because there's a lot of noise about Trump administration trying to take away any kind of public benefit receipt. And the answer is, well, it's not as simple as that. Currently, under the current regulations, the prohibited benefits are, number one, they have to be means tested benefits, which means they're based upon how much money you make. Number two, either they must be used to supplement your income, like receiving some kind of a cash or cash equivalent, or they should be giving you long-term medical facility residence. So in other words, you are in a nursing home. So those are the two. If you look at the USCIS website that explains that particular policy, I would be very surprised. Look, I haven't researched this issue specifically, but I can tell you this. I would be very surprised if Trump administration can change this policy without rulemaking. They have proposed regulations They were never published. They haven't gone anywhere. They are sitting on the shelf somewhere. I did speak about it on one of the NPR, National Public Radio affiliates. I had read the regulations at that point of time, but I personally don't see this being as a problem. You should have a lawyer research this issue for you specifically, but there's no need for you to hold back your naturalization. It's not as simple as Trump would like it to be. So he's tried time and time again to take away our rights and benefits, and he's lost time and time again in courts. I think he would lose this battle if he tried to change the rules of the game midway. Okay. Now, I have a question here from, let's see, this is from Arizona. Okay. Arizona, go ahead, please. Arizona.
Hey, how serious are we on this, like the latest bulletin on July, like which came out in July regarding the same? This was my case, like which you just went through. Right. I just want to understand how serious are this, and if you receive any benefits, I mean, is there any kind of denial? I also hear that if there is any denial on the process, then they would immediately deport us, even though we have like a valid green card.
They can't just immediately deport you. They have to take you to through the deportation machinery. They have to take you to immigration court. It takes year, 2 years to get the trial process wrapped up. They can't just put you on a plane back. And as I explained, there are only two kinds of public benefits that become an issue so far. One is income supplementation and the other is long-term care. Okay.
In the July bulletin, what they say is like, in case if there is any denial, they say like we are not getting any chance to even contest in court.
Where are you reading that, sir?
In the last July bulletin, where they said like all this, like any change in status for anybody for that matter, if there is any change in status even for like H1 or green card or like even like getting a passport application filing, they want RFE.
I think you're talking about the new RFE policy. You're talking about the new RFE policy.
Does that apply for my case?
Which is supposed to become effective on September 11. That's what you're talking about, right?
Yeah.
Okay.
That's correct.
There's a lot of misunderstanding about that policy. That policy simply says this: the adjudications officers have the right to deny any application without issuing an RFE if it appears that the person is not qualified for the benefit. This was always on the books. This is actually a regulation. The regulation allows them the power to deny an application without issuing an RFE where appropriate. But that does not mean they can just deport you. There is another policy they are trying to implement, the NTA policy, notice to appear policy, where if you are denied something, they can try to deport you. And that policy has not been implemented yet. The RFE policy will be implemented on September 11, but that doesn't take away your right to appeal. If they deny something, you can always appeal it. You can even refile the case. And personally, I think they would be singularly stupid to deny cases that are pretty good cases just because they want to find a technicality. That would be a very dumb thing to do. There are dumb people in the USCIS, but not a whole lot of them.
Okay. I just read in some of the news articles saying that some of the people were actually invited to the USCIS office for an NTA, and when they went there, they were like handcuffed and then deported out of the country, even though like
these are people
they were given a message that
these are people who already have a final order of deportation. Okay, they can't just put people on a plane and deport them. People have to be put through the process. The people that you're talking about are typically those who already have a final order of deportation against them.
Okay.
Which means
what I read was like they had
already gone through the immigration court.
I mean, what I read maybe was like, maybe I didn't get it correctly, but what I read was like they were given notices to appear in the court because like there was some more information required on the case, and they were about to get their citizenship. And but to their surprise, when they went there, they were actually asked to deport.
I have actually addressed this issue also in a radio show with National Public Radio. This thing first started happening, I think it was a Massachusetts case, where what had happened was it was a lady who had entered the United States illegally, stayed here for many, many years, applied for green card through her US citizen spouse, and instead of giving her the green card or having her go through the process where she can get some kind of a waiver, etc., when she went for the waiver, they deported her, or they put her in deportation. Now, this is a very unique set of circumstances, and of course that was also court stayed some of that. I think there were 3 cases like that. At least 2 of them were stayed. Third one I think was too late. Don't remember all the details, but one of them was, I think, Boston, Massachusetts case. So these are very unique circumstances. They don't have any application to legally entering people.
Okay.
So I'm not worried about that.
Can you please answer the second and the third one, please?
Yeah. What is the second? But I'm sorry. I'm looking at your question. What do you want me to answer?
I mean, it would actually, because like we are deriving a benefit because our kid has a genuine medical reason. So would that be any hindrance for our citizenship application
I started by saying I haven't looked at this issue specifically. I would have to sit down and spend a couple of hours going over the laws, making sure that there indeed is no issue. As far as I know, this is based upon my knowledge off the top of my head. This particular case presents no problem. But don't take my word for it, have it looked at. Okay?
Okay. And would it make sense for me and my wife to apply for our citizenship together, or should we go for individually at a different time?
I don't see any reason not to apply together.
Okay, great.
Okay. Good luck, sir.
Okay, great. Thank you so
You're
much,
welcome.
sir.
Bye-bye. Okay, going back to, I don't know if there are any other frequently asked questions. So I'm just reviewing first the frequently asked questions. Then we'll start from the beginning and, oh, here's another one. So this is from Smart Shafali. My husband has an I-140 approved for Company A, 2008 priority date, EB2. He's now eligible for EB1 under Employer B, currently on L1A. Can his priority date from EB2 be ported to EB1? The answer is yes. Ma'am, you can port priority dates from EB3 to EB1, EB1 to EB2, EB2 to EB3. As long as it's an employment-based case, the same particular applicant, they can, or beneficiary, they can take their priority date across any employment-based case. So the answer, can you port from EB2 to EB1? Yes. And there is no particular format on how you do the porting. Filing with 2 I-140 approvals and 1 I-485 is just as good. So as long as technically government is supposed to know what is the earliest priority date to which your husband is entitled, you shouldn't have to do anything. This is an automatic process. But just to be even more secure, you could attach copies of both I-140 approvals, explain that he's entitled to this priority date, that's why he's entitled to his EB1 485, and that should be enough. What is the estimate processing time? That you're going to have to go look online. I do not know. Anybody has any follow-up question? Okay, so the main thing is priority dates, EB2, EB1 can be ported, and there's no particular format for it. This is supposed to be automatic. Government is supposed to keep track of that. All right, I don't think we have any other frequently asked questions. Let's just make sure on the next page as well. Okay, there is no frequently asked questions. Now let's go back to answering people's questions in the order that they have posted them. Let's see. So applying for naturalization, it's a whole bunch of different titles. Look, guys, I have definitely a limited time during these calls. There's 21 questions here. I won't be able to go into this much detail, but I can generically answer this. Let us say that you have an internal job title, and the internal top title is engineering manager. And the actual title, according to the government, is software developer. You should go with the internal title, engineering manager. That's the way I do it. I don't think there is any particular rule on this, but if I were you, I would be using those titles by which I was called by the employer for whom I was working. Always mention, and if you are in doubt, you are welcome to provide more information rather than less. So if you have a doubt, you can add a letter saying that this is what happened, these are the titles. What is fundamental in these applications, I think you should talk with a lawyer and maybe just go over your paperwork once. Don't just spend 5 minutes on my consultation here. I can give you some basic ideas, but I can't give you a detailed consultation in the time we have. So talk with a lawyer, get your case looked at. I don't think these are major issues. The general rules are, I would rather use the internal title. The second rule is that it is the job description which is more important, not so much the job title. Okay. And your question about your wife, let's see, am I missing something? You only have these questions about these titles. Have somebody look at your case just to make sure that there are no issues. I don't think there are. Job title variations are always, it's quite a ubiquitous phenomenon. I see it all the time. I wouldn't worry about it, but do have somebody take a look at it. I-140 denial of your wife, unless it was for some kind of fraud imputed to her, should never be a problem. Denial of an I-140 should not be any problem for her citizenship. Star 5 if you have a follow-up question. Star 5. Okay. Let's see. This one is from Arkansas. Yeah, Arkansas, go ahead, please.
Hi, Raju. This is my question. Thank you so much for your answer. Raju, another question is that internal title, it has to be after getting GC, or it can be immediately after EAD? Also, can I have the title? So what is the title? When should I get?
Let's take an example. Let's say your H-1B job title was software developer and your green card job title was project manager. So your future job is project manager. Okay. Now you can take that job of project manager as soon as you get the EAD. Or you can take that job after the green card approval, any time after you get the EAD. The reason I said EAD is because if there is a substantial difference between the job you are currently doing on H-1B, which is software developer, and the job that you would be doing under the green card, which is project manager, then before you take that job, you should have applied for H-1B amendment. Okay. But if you're taking it on EAD, no problem. You can take it any time. The law doesn't require you to wait until you get the green card approval to take that job. Okay.
Okay, Raju. Another question is from employer A, after 2 years, I moved to employer B as a developer from project manager. So is that a problem in naturalization?
No, it shouldn't be. You already had your green card, right, through employer A?
Okay. Yeah. Yes, and I worked for him for 2 years. Then after that, I moved to employer B.
Once you get your green card, you are absolutely free to do whatever you want. You can take a downgrade, you can take an upgrade, you can move laterally, you can change your jobs completely. So, I mean, if you were, let's say you had a degree in finance and a degree in software engineering, and you got your green card as a software engineer, after a few months of getting your green card, you can move back to finance if you want.
Okay, sure. Thank you. So better to go with the internal title. Thank you.
That's the way I would do it. Yes, sir. Okay.
Okay, thank you. Thank you.
Good luck. All right, let's go on to the next question. Oh, there's another one, sorry. Somebody from New York. No new questions, only a follow-up. Go ahead, New York.
My bad. I just did it by mistake.
No
Please
worries.
go ahead.
No worries. It's actually a toggle. If you press *5 again, it goes down. So no worries. Okay, I'll put your hand down. Now we go on to the next question. This is a follow-up question. See, I must have advised somebody that have your wife file the naturalization first and then you file. Sometimes what happens is, let's say you got your green card through an employment-based category and you have some doubt about some issue that could come up during the naturalization. My advice is let your wife go through first, because she doesn't have that issue and she's naturalized. Once she's naturalized, it gives you certain other protections as the spouse of a US citizen. Even if the government comes after your green card or your naturalization is denied, you might have options because your wife has already got a naturalization. This is not a foolproof method. It just gives you an added layer of protection. And normally, if somebody's naturalization is denied, I would have to know what the reason is. If the reason is a fraud or misrepresentation based reason, it becomes very complicated. But if the reason is something like a mistaken 485 approval, it could be perhaps more manageable. But remember, if the primary applicant under the employment-based category got their green card by error, then the derivative, which is your spouse or your wife or your husband, can also have the same problem. But denaturalizing somebody requires a federal court proceeding, which is a lot more cumbersome. And if the issue is relatively minor, governments before Trump may have actually just not taken any action. So let's say if you're married to a US citizen and your green card gets revoked, you can just immediately apply for a green card even while you're in immigration proceedings and ask for adjustment of status from the immigration court. So you have a lot of options that are quite attractive if things went wrong if your spouse has naturalization. As to if one gets denied, the other one gets approved, it's the same idea. One has naturalization, they can sponsor the other one for a green card, even if the worst things happen. Okay. *5 if you have a follow-up question on this. Press *5 on your phone if you have a follow-up question. Okay. This was another frequently asked question that we finished. This is also a frequently asked question. Ashita Sharma. I'm a green card holder. Fiancé is working on H-1B. You are right. You cannot file I-130 485 concurrently unless the dates are current. And you cannot have them stay here unless they qualify for an H-1B. And if the extension is denied, he can always apply for an H-1B, step outside USA, get an H-1B through another employer and come back. That should not be a problem. Are there any other ways for me to keep him in the country? H-1B, Ashita ji, is the most foolproof method, I would say. Everything else is subject to variations, problems, issues. H-1B, even if you have a green card going, does not present a problem. But if, for example, if somebody were on F1 or wanted an F1, if they have a green card going or their fiancé is living in USA, they may not be able to get an F1. So shoot for the H-1B. *5 if you have a follow-up question on this. *5. Okay. I see a bunch of people just logged in. Again, I remind you, we will not have time for new questions. We are just answering the questions that are posted and the follow-ups on those questions. Santosh 321 says, I'm on H-1B with employer A. I have an offer from employer B. Employer B filed change of employer with consular processing. It is approved. I have a valid visa stamping till September 10th, 2018 from employer A. So the question is, can I just go outside USA and come back? Technically, you can. So you have a visa from employer A, but an approval for a much longer duration through employer B. Can you go outside USA, come right back in, showing the visa stamp of the old employer and the approval notice of the new employer? The answer is yes, you can. And they should issue you an I-94 based upon B's petition. That is how it should be. Will they do it? I do not know. I have a client stuck in, I think they're in Pakistan. They have a treaty investor visa, and their E2 is good till October, and the government has him stuck there saying, we will not issue you a visa only for the next couple of months, which is, in my view, illegal, because once he gets back, he will apply for an E2 extension. He's been doing it for years. That's allowed under the law. So this government has been creating problems. Some of them are not even legally permissible, or at least policy-wise, they've never been that way. I don't know what they're going to do. Theoretically, you can do all these things. I don't see any issue in stepping out, showing the approval notice of the second employer, and getting an I-94, which is valid for the duration of your employer B H-1B approval. Star 5 if you have a follow-up question on this. No new questions. Star 5. Okay. Let's go on to the next one. Suresh Ala. I'm working for a major MNC. I guess MNC means multinational corporation. For the past 9 years. And in 2015 H-1B lottery, it was picked up. I could not travel. All right. Location Wilmington, Delaware, where my H-1B was filed. In 2017, I joined another project, traveled to the US upon amendment receipt. And I don't see anything illegal about that. And then also filed for an extension from Project B. Now the question is, I want to go back and join Project A. I think you should do an H-1B amendment, because it looks to me like the previous H-1B which was approved for location A would have been expired by now. So yes, you would have to file for an extension. That's the way I see it. Follow-up question, press star 5. Any follow-up question, press star 5. Okay. Now this is a very difficult situation for Mr. Soni, I assume, Raj V. Soni. When he came back from India, he didn't notice that they issued him an I-94, which expired August 2017. That means you probably are now subject to 10-year bar. You can try to ask the government to forgive your being out of status. They hardly ever do, but you can try. And if that doesn't work, then you are subject to 10-year bar. You have to step outside USA, apply for an H-1B visa. The consulate will most likely deny that visa based upon your 10-year bar, but you can get a 212D3 waiver. You can at least apply for it, because the 3-year bar does not stop you from coming back to USA on an H-1B if you have a 212D3 waiver. So you won't be able to get a green card, but you can spend a considerable amount of time, 4, 5, 6 years, or as much time as you can get, based upon the 212D3 waiver. It's a long discussion, but those are the choices you have. Try to get a quote-unquote reinstatement or a Nunc Pro Tunk reinstatement. It's unlikely, but not impossible. May even think of going to court over it. Might be worth it. But if that doesn't work, then you step outside USA and get yourself a new H-1B visa, which they will of course deny, and then get a 212D3 waiver. Normally a waiver should be available in these circumstances. Okay, so 2 things you need to remember. apply for Nunc Pro Tunk, which is retroactive approval of the H-1B, and 2, apply for 212 D as in doctor number 3. That's the name of the section, 212 D3 waiver. Star 5 if you have a follow-up question on this. Okay. Raj Dab says, he looks like Salman Khan. I thought it was Salman Khan's picture for a second. I have applied for H-1B visa and got an RFE. I'm on F1 CPT. If my H-1B gets denied, yeah, your CPT is still valid. That's not a problem. If the H-1B gets denied, your CPT is still valid as long as you're going to school. If the H-1 is approved but the change of status is denied, that would only be because they don't accept that you have maintained status. Then you would have to go outside USA for visa stamping on your H-1 and come back. And I don't think you'll be able to change to any status within the United States, Mr. Dab. Star 5 if you have a follow-up question. Because if change of status is denied, it's because they are not convinced that you are maintaining status. And if you are not maintaining status, your only remedy is to go outside USA, get an H-1B visa and come back. Next question is, this is the Canadian citizen living in USA on E2, which is a treaty investor visa. Applied for EAD card I-765 on January 8th, being processed in California Service Center. In May, we sent some additional documents for RFE, filed a case inquiry. It's been a long time. What can we do? I don't think lawyers can do much, but if the case is beyond its normal processing time, you can certainly contact your Ombudsman's Case Assistance Service. You can also contact your local congressman's office. Star 5, if you have a follow-up question on this, press star 5 on your phone. Okay. Next one is a frequently asked question. We've dealt with that already. Then the next one is Anoop GC. I have to renew my 10-year green card. I need my permanent address in USA. So they are a little confused. When I first entered USA as a CP, I guess consular processing, 10 years ago, I'm not that concerned about what address you gave. If you have this problem about remembering, you can attach a letter that explains this issue. So just say that I tried to get this information, I don't remember what I put there. So I don't think that should be a problem at all. I don't think if you have not been able to get this information through a Freedom of Information Act request, I don't see how else you can get it. And I don't think this is critical anyway. I don't see this as a problem. If you have any doubts about this, you should go ahead and attach a cover letter or an explanation letter. I don't think this is serious. Star 5 if you have a follow-up question. Star 5. Next question is from New Andhra. You see, you are a student, you want to be outside USA after getting your green card and then get naturalization. Doesn't work like that. Doesn't work like that. First of all, remember, if you're going to be outside for extended period of time, make sure you get a re-entry permit. Re-entry permit is very important. Otherwise, your green card can be taken away. Second thing, naturalization rules require physical presence of at least 2.5 years, 30 months in the last 5 years, immediately prior to filing naturalization. There are other rules, but this is one of the rules that would be a problem. Other rules are like your stay outside USA should never be 1 year at one go. If your stay outside USA is more than 6 months, less than 1 year, you have to explain. So there are all sorts of rules. But first of all, I think you would fail the rule of 30 months presence in USA. Star 5 if you have a follow-up question. Now, I always dislike the idea, this is Sara Vav or Sarva V. This is always a problem when somebody enters USA on a B2 visa and they have an intention to convert to F2 or any other status. That can be considered to be a fraudulent entry. Don't do that. If they have been rejected an F2 visa, I would be very reluctant. I think you should look at H1, but entering on a B2 visa then converting to F2 I think is a bad idea. *5 if you have a follow-up question. *5. Okay. Lucky has a question about to marry an LPR, a lawful permanent resident, a green card holder. Someone suggested me to get B1, B2 before marriage. That would be fraud. Even if it didn't get rejected, to try to enter USA on a tourist visa and with an intention to stay here, that would be fraud. Do not even think about it. I think H1B is the better way to go. If you can get a job in the USA and get an H1B, H1B is not affected by your spouse being in the United States, or even if you have a green card going. F1 visa, all those other kinds of visa, if you have a B1, B2 denial on based upon 214B, you're going to have the same problem on your student visa. Shoot instead for either H1 or L1. Those are the only two visas that make sense under these circumstances. *5 if you have a follow-up question. *5. Okay. So this question from Surekha Suresh says, how do I transfer J1 to F1? Currently doing PhD on J1, plan to get F1 to continue my PhD. How do you convert your I-20, or is there any other formality needed on I-20? That your school can tell you. Are you on the phone? If you are, press *5. Press *5. I have a question for you. Okay, I'll try to cover both eventualities. If your J1 is not subject to home residency requirement, you can apply for change of status within USA. If your J1 is subject to home residency requirement and you have not yet obtained a waiver, you will not be able to change status within USA. You have to go outside USA. So check on the I-20 issue with the school and the J1 to F1 conversion based upon what I just told you. *5 if you have a follow-up question. So next question is I-485 help, which is a repeated problem because the USCIS keeps messing up their daughter's name. So I don't think the extra initial on her card is going to be a problem for naturalization because you've tried to correct it, and you can bring that up with the government that look, we tried to correct it and you guys have been messing it up every time. So I think that should be okay. I don't see it as an issue. *5 if you have a follow-up question. *5. Okay. So let's do the last question. As luck would have it, I have about 10 minutes before I have to hang up, so we might be able to do some new questions. The last question that I have posted today is Psi 320. H1B is under transfer process from A to B, degrees in mechanical, working in software. It looks like your RFE has been submitted, responded well, but they sent a second RFE. This time they asked only for pay stubs. Does it look like this is going to get approved? Yeah, I think so, because normally if they have not raised any issue about specialty occupation or your qualifications the second time around, my guess would be, now this is not guaranteed, but my guess would be that this case should go through. But with the government you never know. What is the trend of second RFE? We get them occasionally. They're not very common, but they are not exactly a huge bomb either. They're not a huge surprise. *5 if you have a follow-up question. Alright folks, anybody has any question, press *5. We have a few minutes. I'll try to help as many people as I can. So we've got one person with their hand raised. Good. Don't have too many. So this one is from Pennsylvania. Pennsylvania, go ahead. I can hear you.
Hi Rajiv, good afternoon.
Good afternoon, sir.
Actually, there was some news I read like H4EAD Trump government putting an end soon. Do we have any updates on that?
Well, they were supposed to publish some final regulations, or at least proposed regulations a few months ago. They haven't done that. What the news simply says this, that the Trump administration is trying to tell us that we haven't forgotten that we need to cancel the H4 regulations, H4EAD regulations, but there is no news beyond that. They have simply said that we intend to revoke these regulations, but they were supposed to do that a few months ago. Okay?
Okay, so even if they revoke it, still if I have the validity, say like until next year, can I use that?
I don't know the answer to that question. When they propose the regulations, then we will know better what they are thinking. But one thing is for sure.
Okay, Rajiv. Thank you very much.
One thing is for sure. They can't just do it overnight. You'll have a few months at least. Okay?
Okay, got it. Thank you very much.
Good luck, sir. Ladies and gentlemen, it's always fun to talk with you, and I feel very honored to be able to help people as best as I can within a few minutes of my time. I'll see you again in 2 weeks. Thanks for attending. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.